I guess we are using the computer audio. All right. Contracts are important for any business that has independent contractors or employees. True independent contractors, shaky independent contractors, any kind of independent contractor, and all employees, because every employee has access to proprietary information. Some hot, secret, spooky information they have. Patient list, insurance company, billing rates, reimbursement rates, arrangements with particular patients over what they're going to be charged. All of that is confidential information in the business. And every one of those people should have signed or should sign a non-disclosure agreement, a confidentiality agreement, something like that. Very simple to put together, pretty short and sweet, even for me, a page and a half. And it basically contains a promise by the employee or the independent contractor that they will use that confidential information exclusively for the benefit of your business and for no other purpose whatsoever. And when they leave, they can't take any of it with them and they can't make any use of it. So let's talk for a minute about how valuable that is. And this is a barometer of cynicism for me, because employees having signed that will then leave. What percentage of those people who signed a non-disclosure and leave will honor it? Because they're good people, they're signed by their word, and they live by their contract. For me, for illustrative purposes, I'll say 60%. I may be more or less cynical than you, but it's a reasonable assumption. So that piece of paper gets you compliance for 60% of the people who sign it. Then there's another chunk of those former employees who forgot about it. And when they leave and you find out that they've started to breach it, you write them a letter. And maybe you copy in, I recommend you copy in their current employer. And that starts those people to come into compliance. So some of that remaining 40% will come into compliance. Let's say 20%. So now you've got 80% of your former employees in compliance with this agreement. The other 20 are just outlaws. They're thumbing their nose at you. And yes, you have a right, because they breached the contract, to take them to court and sue them. That is not a win. Because it's expensive to litigate and it's disruptive and it's just a disaster. So it only makes sense to pursue litigation in a situation where the information is so valuable that you, for whatever reason, you cannot tolerate having it be disclosed. I don't know what that would be. But the important point, though, is the perspective. For really not that much money in legal fees, and a simple agreement that's not intimidating, that's written in English, you get 80% compliance without having to spend another dime, in my world, with my assumptions about human beings. I think every employee and every independent contractor should have non-disclosure agreements. That includes our business as well, but and it's an easy program to put in place, because once you craft the agreement, it's very easy to make use of it with all of your employees going forward. So non-disclosure is one of the 3 restrictive covenants that we talked about, or I want to talk about, I should say. So let's try the whiteboard for fun while we're here. All right. What did I do? Text? Is that what I did, Michelle?
Yeah.
Okay, so Okay. We're having a night for technology, are we not?
We are.
3 N's, I call them: non-competition, non-solicitation, and non-disclosure. Folks not in the legal business tend to lump those all together and call them non-competes. We need to be a little more precise with our concepts. Non-competition says thou shalt not say practice as a therapist for anybody in this geographic region and for this period of time. Non-solicitation says thou shalt not act as a therapist for these specific patients who have been continuing and long-time patients of your practice. It's different from shutting people down from practicing as a therapist 100%.
I just sent the new link.
Okay.
So they should be connecting with you shortly.
Okay.
Thank you.
Sure. Let me know if you have any other issues with it.
All right, thank you. And non-solicitation also runs to employees. So if you've invested a lot of time and energy in training an employee and making them understand how your business works and what they do for your business, you can extract a non-solicitation promise that no one will try and hire those people away from your business after they leave. And then non-disclosure is the last one. Of those 3, non-solicitation and non-disclosure are easily enforced. There's a perception, I think, by lay people that lay people was the pejorative term that we used in law school for non-lawyers. Forgive me, it just slipped out. People tend to think they're non-competes, and they think non-competes are unenforceable. And they have good reason for thinking that. But non-solicitations and non-disclosures don't have problems with enforceability. Those are enforceable. If you have to go to a court to get them enforced and get a court order saying somebody cut it out, you can't easily with those. Non-competitions are different. Courts don't like. Hi, Susanna.
She's blocked on. She has her.
Oh, she's muted. Okay. Courts don't like to deny people the ability to make a living. And the non-compete, because it's the broadest and most effective tool, denies people the ability to make a living. They're all subject under state regulation. California has made it unenforceable by statute. You cannot sign an individual to an enforceable non-compete in California. It's just gone. For it to be enforceable, it has to jump through some pretty important hoops. One is it has to be reasonably related to protecting the business's legitimate business interest. So I'm really struggling to come up with a meaningful example for folks who have solo therapy practices. So I'll use an example from another business. Home remodeling business. Somebody gets trained as a designer, brought along by the owners, does a really good job. Now they leave and want to start their own shop and they want to compete. Well, if that owner had been well advised, would have put in place non-competition restrictive covenants with that particular designer. And whether or not those non-competition provisions are enforceable depends upon, among other things, the relation to the employer's legitimate business interests. So they're in the remodeling business, very competitive business, but it tends to be pretty condensed geographically. So if there's a possibility for this person who leaves to take away business from this former employer, I think that's enough of a connection. There has to be consideration given for the promise not to compete, which means It's an awkward use of the word consideration. It just means you get something in exchange for the promise not to compete. And courts will often pick at that requirement to try and find a way not to enforce the non-compete. It has to be reasonable in terms of its geographic scope, and it has to be reasonable in terms of its duration. So if the guy was working for a home remodeler who was doing work in Allegheny County and Butler County and Beaver County and Washington, the other 5 surrounding counties, if we were to put in place a restrictive covenant that prohibits them from doing home remodeling in everything east of the Mississippi, every state east of the Mississippi, doesn't make sense. It's not related to that reasonable business interest of the business. And so that's not going to be enforceable. It's not going to be effective. How long is he stuck with this? He or she, the one who's left and started their own business, how long are they stuck with it? 10 years, 20 years? Well, that's not going to fly. Courts won't tolerate that. In the employment context, I'm really comfortable with 2 years being the longest, and I'm happier at 1.5 years or 1 year. And I'm happier whether I'm representing the employer or the employee, because if I'm representing the employer, I want them to have something that has teeth in it, that if we have to go to a court to enforce, the court's going to say, pretty reasonable. And if I'm representing the employee, I want it to be as short as possible. So,
Well, Mark, if the practice grew large enough to such a practice as like Kevin's, can he enforce those contracts with the therapists that work here? So could he, if somebody wants to leave and go practice on their own, can he?
do they have, let's assume they have an employment contract that has a non-compete provision in it. And if it's written properly, and if the employee gets something for it, that's the consideration, then yes.
Okay.
And what happens is you hire, when somebody leaves, starts competing, the employer hires lawyers, the lawyers go crazy, and we try to get a preliminary injunction. So it's a very intense, disruptive, 6-week-long process, expensive, and you end up in a hearing in front of a judge, establishing the authenticity of the documents, explaining the conduct that's being pursued by the former employee, and it can be just debilitating, but it's over quickly. That's the good news, it's over quickly. But I'm cynical also about courts and why they make the decisions. I think courts very early in a proceeding, and when I say courts, I mean juries if it's a jury trial, and judges if it's just a bench trial, no jury. I think they figure out pretty quickly who they think the good party is and who they think the bad party is. And then they make their decisions to try and, or their rationalizations or explanations of their decisions to try and reach the result they want to reach. Some people call it results-oriented judiciary, something or other. Courts, as I said, generally don't like keeping people out of a job. So they'll try to find a way to fail, to have an employer fail on one of these things. For instance, when you hire a new employee, you need to have them sign the employment agreement that contains the restrictive covenants before they start working. That way, you giving them the job and allowing them to come and work for you is the thing they get that supports their promise later not to compete when they leave. I've seen a case, I don't know if it's Pennsylvania, I can't remember, but I've seen a case where allowing an employee to work for a day, and then on day 2, HR shows up with the employment contract, asks them to sign it, and they challenged it in court, and the court threw it out because you obviously gave this employee the job and you didn't ask the employee to sign the restrictive covenants. So what did the employee get for this? Nothing. We always put money on the table. My clients, that's what I recommend to my clients. Let's put money on the table. If you want somebody who's already an employee, and maybe some of Kevin's people are like that, and they're getting really valuable, and you're getting ready to make a big commitment to them. Maybe we want to get put a non-compete in place, and maybe it makes sense to give them a bonus at the time they sign the agreement. That gives you plenty of consideration. We're talking about restrictive covenants in general, non-competes specifically.
Every staff member I have has them.
Really?
Everyone.
How long do they last?
2 years.
And what's the geographic
30
restriction?
miles from any office.
30 miles from any office. I like it. It's within the realm. It's within the realm of the reasonable.
But I think, and we're going to talk more about this because we're going to be doing at the very end of this back in or into June, when we kind of do the talks from CBI's perspective of, you have to pick the right employee. You have to do that qualitative questioning, not just a resume, because we've hired probably close to 70 people here. We've learned a lot. We want the right person, and we've really gotten good at that. And at times had to clean house. And what that has allowed us to do is not spend any time on HR and not have really much turnover. So although it sounds heavy, I will say you can do it in different ways. I've been creative. Mm-hmm. So we do have the restrictiveness, but it's restricted to private practice, right? So you don't want someone to starve. So if they want to go work for a nonprofit, UPMC, Highmark, they can, right? So you're not keeping someone from making a living. But we've had people come here trying to get a secret sauce and leave. We have people come here, they're credentialed, not see a client and leave. So one of the other things, if people leave within X amount, they have to reimburse us X amount of money for credentialing. I invest heavily into trainings. I've told you what we're going to be doing outside CBI, but I have people certified in Gottman that I've spent money on. That's, $6,000, $7,000 in 2 years. I have a second person doing that. I have other people certified in other things. It's time and energy, and so I want people to stay here. I create a good environment here. People get chair massages once a month. Here we have them come in. We're having Friendsgiving tomorrow. Family and all the staff will be here. Invite people over to my house. I have season tickets to Seven Springs, which you're all welcome to during the week if you want. Also, 4 tickets that you treat them. I treat them well with respect. I really get them engaged. You have to take a really comprehensive approach to creating a culture, which we do here. We spend a lot of time and energy, so people don't want to leave when they come here. And truly, when people come here, they're valued. We invest in them, and they want to stay. And to be honest with you, because of our size, you're not going to make that. When it comes to your time and cost in private practice at this point, the individual practitioner, I don't know if you're going to make more working on your own than you would here anyway. So, and you create that type of environment, people want to come, they want to be here. And there's a lot of other things I can go on about, but I think it's important to culture to keep people happy and bring the right people on. They will burn you if you don't.
You've lived the other side of that.
Yeah. And to be honest with you, the non-compete, I ask a lot of qualitative questions during an interview, and that has really helped us out a lot. You watch people react, and I can tell when people are looking just to come here, which they have the right to do, but I also have the right not to want them here, to kind of get the secret sauce and leave. I can pick them out every time. Those individuals, they have the right, but I don't want them coming here because I'm investing in these people. I want them here for life, and I treat them that way. I treat them like family. And so, I would just say, if you're going to grow, treat your people well and screen well and treat them well.
Right.
And sign a restrictive covenant.
And at what point in the process do you get them to sign the employment agreement that contains the restrictive covenants?
So typically people go through 1 or 2 interviews, we review their resume, and then if we think they're a good fit, then we do a phone call, set it up, and that's part of our screening process sometimes. Then they get set up with 1 interview, and depending on how well they do, it'll end there, and then I'm always the last person to see them, and I discuss the contracts, and that's when I talk to them about it.
And you make an offer, and they have to sign it before they start working.
Correct.
Yeah. Now, we were talking about the consideration piece and how courts don't like restrictive covenants and look for reasons to throw them out and not honor them. And if you allow an employee to start working before you ask them to sign a restrictive covenant, it's no good. It's not good.
No one works. Usually it's several months because they have to there's a lot of paperwork that has to be gathered for credentialing. Typically, most people are credentialed. We're not credentialed with anybody. We do all the credentialing. We do white glove service for of staff here. So it takes a while to get people ramped up
Right.
to where they are. But yeah.
There's something called the Interim Effect. And I just want to mention that because I'm aware it's fun to use Latin terms. No, not really. But so that somebody comes along, signs an employment agreement a month into their term as an employee, don't get any additional contract or consideration, don't get anything for it. So if a court of law were to look at it, they'd say it's not enforceable. The interim effect happens when the non-lawyer employee reads the contract and believes that it's enforceable, even though we all know it's not because they didn't get any consideration for it. And so they choose to live with it, even though it's not enforceable.
So you're saying non-compete is not enforceable?
Yeah, I'm throwing out a fact pattern where the non-compete's not enforceable because the employee didn't get anything in exchange for that promise. In other words, you waited until a month or two after they began to work.
Oh, so they've worked, not that they've had time to consider sign and then the process starts here after they sign.
No, I know. You're
You're saying that's fine. You're saying that's fine.
That's fine. I'm talking about somebody who's not running things not running as tight a ship as you are. And I've seen it. I've seen it happen all the time. I've seen organizations decide, oh my God, we've got all these people working for us who don't have non-competes. Let's get them all to sign non-competes. And they send out the poor HR people with a new agreement and ask them to sign. Employees are not getting anything for that. So that if they ever had to challenge that non-compete in court, they would win. The employee would win. The employer would lose because there's no consideration for it. But the interim effect is it's what happens when the poor employee does not understand or know that they need to get something in exchange for their non-compete promise. Mm-hmm. And yet they assume that it's enforceable and meaningful anyway. And
can you give an example for that? Sorry, I got dropped from the call. So can you give an example? Go back. Maybe you gave that already. But like if I don't have this scenario, but I just wanted to hear, kind of own the thought.
Sure. I'm trying to think of the ones that I have talked to. Generally, they're in larger companies where that have HR departments that are a little bit insulated from senior management. So somebody in senior management gets the idea that we've got a hole, the back door's open, people can leave, they can take the secret sauce, and we can't have that. We've got to get them all signed up to non-competes. So maybe, just maybe, the company's lawyer says, wait a minute, we got to give the employees something to make those things enforceable. And the client says, okay, what do we got to give them? And if I'm the lawyer, I say, a bonus, $200, $2 or $3 grand. We got to give them a bonus. And the client says, whoa, that's a lot of money. I got 50 employees. I'm not spending $100,000 to get this in place. And I said, okay, then we got a problem. And I start talking about the interim effect. And I'm not happy about myself doing this, by the way, but I say, okay, are there certain of these 50 employees who are more important that we get them to agree not to compete than others? Are they farther up the food chain? Are they more highly compensated? Maybe we do something where we just do the top 10, we give them money. And so we can bank on those contracts being enforceable. The other 40, we're not so worried about them, but we want to have non-competes in place. Maybe they go out to those people and they ask that 40 to sign and don't give them anything, counting on those employees to believe now that they're subject to a non-compete. That is the interim effect. And it's a weird thing and kind of a cool thing. But I also know people who are in that 50 who will find a way never to sign it.
Well, and I think the way you prevent this is the reason why I'm bringing the Lynch Law Group in here is right. So part of why I can speak to a lot of this myself is because I've been there and done that. So I had the processes up front when I realized, something here, I'm going to start growing this. And I never knew it would get this big, but when you have those processes in place, you don't have to sit back and worry about that. You sleep better at night. And so sometimes, lawyers, they're expensive and you feel like, we don't have to deal with them. But what happens when you get burnt, which I have, you can prevent that and sleep better. And don't lose 6 months of your life worrying about a distraction from what you could be doing from your business. And so that's where I think, reach out to them. I think it'd be very helpful, those that are here today, or maybe do this in the future, is all these things are preventable. All you need to do is consult early on, plan for it. And then so whenever someone were to challenge it, you have all your ducks in a row, or they know better not to because you've done your due diligence. And so that would be my advice.
I certainly share that, Kevin, and thank you for that. I have some Fram oil filters in my office, and Michelle is smiling because she knows what this is about. In the early 70s, I'm dating myself, there was a commercial on TV for Fram oil filters. And it featured a guy in some greasy overalls, wiping his greasy hands on a greasy rag with an open hood to a car behind him. And he says, you see this guy? He needs a new engine. That's about $1,400. It was 1972. You see this? And he picks up a Fram oil filter. It's about $4, $9 today. If this guy had had regular oil changes and had used Fram oil filters, he wouldn't need a new engine. Me, I don't care. You can pay me now, and he holds up the $4 oil filter, or you can pay me later. And he points at the remanufactured engine for thousands of dollars. And it's hard, and it's reasonable for starting your own, if you're starting your own practice, to focus on building the book of business, building the patients, getting the money flowing, and not worrying about the legal niceties. However, sooner rather than later, as soon as you can, you got to get the legal niceties in line, or you'll pass later.
You want to get the accounting, otherwise that will come to bite you. You want to get those all in. So we're going to continue the series along with the Lynch group, starting in 2020 again. I think there's several more you'll be doing, as well as some other topics. So continue to come, continue to follow, and hopefully we'll prevent you from having to deal with all this. Just want to thank the Lynch Law Group and everybody attending tonight. I know you guys are running overtime, so thanks. I know you probably all want to get home. But otherwise, Beth, thanks, and you all have a good night.
Thanks, Kevin. Appreciate you all. Take care, Sarah.